Good morning, everyone, and welcome to our Beasley Allen webinar presentation featuring an ethics update by Alabama State Bar Ethics Counsel, Tripp Vickers. As many of you know, Tripp has served as the bar's ethics counsel ever since the creation of the position in 2017. So naturally, we are very, very honored to have him here with us today. And during today's program, Tripp is going to share his unique perspectives on the legal profession and the state bar's role in governing and supporting Alabama lawyers. Tripp's also going to bring us news and announcements from the state bar. He'll discuss the structure and functions of the Office of General Counsel. And finally, he'll provide an overview of the state bar's ethics division and the informal opinion service. Now, before I turn the program over to Tripp, I do need to go over just a few CLE-related housekeeping notes. First, today's webinar has been approved by the Alabama State Bar for 1 hour of CLE credit. In order to receive full credit for attending, you've got to stay on for the duration of the program. A link to today's program was included in the Zoom confirmation email you should have received when you registered. Now, that confirmation email will have slides. If you did not get slides in that initial email by the end of this week, you're going to receive another email and an evaluation form. That will include the slide set. You can send your evaluation form to webinars@beasleyallen.com. Let me give that to you again. You can send that completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded. And for those Alabama attorneys participating by phone, please email us your name, phone number, and state bar ID number. You can also send that to webinars@beasleyallen.com, and that will help us ensure that everyone watching receives full CLE credit. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be hosting a wide variety of new programs and other special events throughout the coming year. So we look forward to that. Check us out again on beasleyallen.com/events. Finally, if you have questions during today's webinar, I want to encourage you to use that question and answer feature located at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle all the questions submitted by our viewers. So with that, Tripp, the floor is yours whenever you're ready.
Thank you, David. Glad to be here today. As David mentioned, my name is Tripp Vickers. I'm Ethics Counsel State Bar. I've been the Alabama State Bar since 2013, and since 2017 have been serving in the role as Ethics Counsel. I know the General Counsel, Roman Shaw, really wanted to be here with you today, but he had a scheduling conflict that kept him from able to do his presentation. I know he likes to do it. But hopefully I'll get you through. We're going to cover a lot of some topics. I have a lot of slides that we can go to, give you something to look at. Some news and announcements, talk about the structure of the Office of General Counsel, the Ethics Division, and what we can do for Alabama lawyers. Talk about the Ethics Division. I mentioned some scams targeting Alabama lawyers. And then there's some question time. I have some questions that I could ask you to kind of quiz you on some rules of professional conduct, and it might be hard to do with this format, but a lighthearted way to go through some of our rules of professional conduct. I will start out with some state bar news and information. Tom Perry is the new bar president. I say the new bar president as of this July. He is from Demopolis, Alabama, and the president-elect is Fred Helmsley. He'll be the president next year. What Tom has done with his executive council is great. He has a diverse executive council, which has diversity in a variety of areas, including size of law firms, types of law firms, areas of the state, and has some rural representation, which is great. This is consistent with with his Harvesting Hope initiative, which focuses on the need to provide legal services to rural communities. We have a dearth of lawyers available to represent rural areas of the state, and Tom is keenly aware of that and is working on a plan to try to recruit attorneys to practice in rural areas to serve those underserved communities. Now, this access to justice issue dovetails nicely with outgoing President Brandon Buck's Justice for Alabama initiative, and that initiative focused on providing information out to members of the public so they can have access to information about lawyers and better be able to find legal help when they need it. That program including scannable QR codes in courthouses and other areas where people in need of legal services could quickly find information, be connected to lawyers. Part of that was the creation of a comprehensive legal aid directory with streamlined navigation, which allowed to empower members of the public with information about the legal field and also the ability to connect to lawyers. Think about what it does is it places people where they can, through questions and answers, sort their way through and find an attorney or answers to their legal questions. Now, what can you do as an Alabama lawyer to make this program work better and also to help you generate business in your practice? You can go on your state bar member page and provide additional information on your profile page about the areas in which you practice. That way, people in need of these services can search and find you and connect you for paying legal work. I've also announced that there are some new member benefits for this year. The smoke ball billing trust accounting software, we've got reports that's a very useful member benefit for those who have a very rudimentary trust accounting software system, maybe Excel spreadsheets and whatnot. Some folks have that where you can use this billing software at free of charge and can cover most of your accounting requirements, and it's received positive reports and has replaced for many lawyers services that they're paying a relatively significant amount for on a monthly basis to keep up with this information. The bar is also partnered with BetterHelp to get free counseling services for bar members 1 month at no cost and a discount for a period after that. So if you think you might need any sort of mental health assistance, or even if not, it's a part of your license, so your fee. So take advantage of the counseling from BetterHelp. And now, as you all know, it is the most wonderful time of the year. It is CLE season, right? So remember, everyone has to get Alabama lawyers, unless you're 65 or older, need your 12 hours of CLE credit. One of those needs to be ethics, and you all are getting your ethics hour today. You can get 6 of these hours, have to be in-person presentations, but 6 can be on-demand courses where you go online and review those courses. In order to get to these, we have a number of free courses provided by going through the State Bar, through your member login page. That's that link in the upper right-hand corner of the front page of the State Bar website. You can log in, you can find out about your CLE transcript. You can see that, see how many do I need, how many do I have carrying over. In the lower right-hand corner, you can go click on free CLE classes and see some CLE options provided by top class. So you can go to these top class, take these top class courses and get up to 6 of your required 12 hours for the year to make sure that you are in compliance with that requirement. We'll move on a little bit, talk about the Office of General Counsel and its organization. The Office of General Counsel is supervised by the General Counsel and split up into 2 divisions, the Ethics Division and the Disciplinary Divisions, which are physically separate and have separate duties. The General Counsel, Roman Shaw, former judge here in Montgomery, does an excellent job handling all of the bar's general legal needs and supervises the 2 divisions, the Ethics Division and the Disciplinary Division. The Disciplinary Division is the one that you might be familiar with. It does the not so fun stuff, which is investigating, prosecuting bar complaints primarily. It's staffed by Jeremy McIntyre, who's the Deputy Chief General Counsel, and Mark Moody and Autumn Faudel, who are the Assistant General Counsel. Their primary role, when you think of it the most, is probably the investigation and prosecution of bar complaints. They also do other things like representing the bar in character and fitness fields. They deal with the CLE non-compliance and receive advertising filings and some other associated tasks. It's important to let everybody know that the Office of General Counsel is now paperless. Whereas it used to be when you get correspondence, if you get a bar complaint, you get a letter from the Office of General Counsel. Well, now you're going to get a notice of a bar complaint electronically via an email, and also information be placed on your member portal. So the details of your disciplinary matter aren't going to be an email, but it's going to get an email that says log on to that member portal. If you are like me, you might have gone years and might without using your member portal because it's just not something you often use. But we are transitioning to an area where that's going to be how the Office of Counsel is going to deal with the grievance process and also provide other information. So when you go on this, you can not only use this portal to respond to bar complaints, but you can also go back and see old complaints that might have been filed against you. You can file petitions, reinstatement, transfers to inactive status, UPL complaints. These can all be due through that portal. So make sure you have your correct email address on file with the membership division, and so that when you get these emails that you get notice and you check them and can timely respond when they ask you to provide a response within 14 days. Now, it's possible that maybe you set up rules where you have bar correspondence go to a very special folder because you want to review it, but you're going to review it later. Or you might have an active spam folder, junk folder. Because this correspondence is going to come in that way, you can make sure you monitor it so you don't miss a disciplinary notice, which I'm sure it doesn't happen very often, but sometimes getting these sort of notices is just kind of the cost of doing business that bar complaints are filed without regard to whether they have any merit. So it's something to be aware of. We talked about that location that's on the upper right-hand corner. Use your member login, and to see the discipline portal, there's a link on the left side where you can click and hit the discipline portal link, and then inside that link you can find a list of bar complaints filed against you. You can find links to file document petitions, complaints, find security fund claims. There are links there, and when you click inside a disciplinary matter, if there is one, it will provide information like the investigator and have all the documents for that complaint. Your correspondence, you'll upload responses there, and you go back and look at things and communicate with the Office of Counsel that way, the disciplinary division. There's that disciplinary division is one division, and the separate division, the ethics division, and the ethics division is me. I do, of course, supervised by Roman Shaw. He also provides opinions, but I am the ethics division, and I am glad to assist you via telephone or emails. Include emails to the ethics at Albar address. Those are forwarded to me. What do? I provide informal ethics opinions and whatever else they ask me to do. I also provide some CLE presentations, which means sometimes you won't be able to promptly get an ethics opinion because I'll be doing that. But my primary duty is to provide informal ethics opinions to Alabama State Bar members. What are these? These are I provide Alabama lawyers with confidential opinions regarding the ethical propriety of their own prospective conduct based upon a verifiable set of facts. The service for Alabama lawyers. If a lawyer in another state calls me the question, I'll provide them guidance, but some of that I can. But the opinion service is for Alabama licensed lawyers. It's a confidential opinion service. Confidential meaning it's the information that is disclosed to me in opinion request. It's not disclosed to the disciplinary division of the Office of General Counsel. It's a service that means that we can confidentially discuss something so you can determine what's the appropriate course of action for you. It also deals with the opinions relate to your own prospective conduct, not the conduct of other lawyers, and not whether someone else did the right or wrong thing. And it's also directed toward prospective conduct, right? What you propose to do in the future, not those things that have already happened. When with these questions are not going to be purely hypothetical questions I answer with you, but if we have a verifiable set of facts, what you're actually dealing with, I can provide you the opinion. Now we talk about a verifiable set of facts. When we provide the information, you can provide it however you like. Oftentimes, if you might give a person's name and the plaintiff's name, defendant's name, the prospective client. I'm going to use the names plaintiff, defendant, prospective client. I might label them as XYZ, just so I can keep up with things in that way, because sometimes it's not necessary for me to take down all of that information to keep it in my records in order to give you an answer. But the facts need to be verifiable, because if you're going to rely upon these opinions, it needs to be sent back. We can go back and see that the information you provided to me in the telephone call or the email or the letter is the information, is accurate information, so that if you have an opinion that you can rely on. We talk about these opinions. One way to think of them also, these are a shield. It's a shield against this office. I'm providing you something that helps you a defense or a quick answer to a bar complaint. It's like, no, we already discussed this. It's a shield against disciplinary proceedings by our office. It's not a sword to go wave around in a courtroom or tell a court how to rule, or tell opposing counsel what they're doing is right or wrong, or to defend your conduct as it relates to the proceeding itself. These are confidential opinions that are between us. Now, they are maintained in a database. So if we do it by telephone, which 95% probably of the opinions I give are done via telephone call, they are going to be saved. We'll take notes and they will go in a database. If we do it by email, the email will also go in a database. It is a database for my office, and the lawyers in the disciplinary division don't have access to that. In the same way, I don't have access to their information. Now, another thing about this opinion service is it's not going to answer legal questions, right? It's only going to answer professional responsibility questions, which sometimes they're so intertwined, it can't answer a professional responsibility question because it depends upon a legal answer. It is also not going to try to address issues which are properly before court. It is a service. It's not a hotline. It's not 24 hours a day, but during working hours, Monday through Friday, there will be someone staffing the telephones and answering the questions. Or if they're not, because, for example, they are doing CLE, if I'm busy doing CLE, I will get back to you. And my telephone voicemail outgoing message will let you know whether how long to expect, if there's an expected disruption, if it's something that you might not get a call back today, or it might be more time. It'll try to direct you that way. So I do try to get answers pretty quickly, but that doesn't mean please don't wait till the last second. Most of the answers I'm able to provide the same day. Now, if you ever don't get an answer from me, please don't hesitate to follow up and check in. Sometimes sometimes emails do go to a spam filter, or if it's a situation where you've called and left a voicemail and you haven't got a response, call and check back. It might be it could be something overlooked. It rarely happens, but it will not. Don't hesitate to call back and ask if there's a reason why you haven't got an answer in 1 or 2 business days, because there usually is. It's usually something that is often more information is needed, or it could be that I am. It's a more difficult question. I'm trying to go make sure I'm providing good guidance. But you can call, email, or write. Difference in these, the telephone calls is quicker and it's preferable. You can send an email. If you want something in writing, it's often better to start with a telephone call, so we're more efficient with your time. Sometimes if you write an email, you might spend your time asking questions that I can't answer, or providing information which really doesn't assist in the analysis. But we can narrow that down and probably provide a more professionally provide an answer to a telephone call. And if we need to put something in writing, we can follow up with that. But you're certainly welcome to email if that is your preference. So you can write a letter too, but if you write a letter, it just takes longer, because by the time the letter is received and makes it to my office, and then I provide an answer, and it looks real pretty, it just takes longer. So most things that are done by letter could just as easily be done by email, if not by telephone. I'm happy to do it however you would like. But that's just a way we can be more efficient and sometimes work our way through to get to the format that's best for you. Sometimes it's easier to think about what I do by thinking about the limitations and what I can't do. I mentioned before, legal advice. I can't provide an opinion on something you've already done. And I can't provide you an opinion on another lawyer, whether what they're doing is the right or wrong thing. I also can't answer hypothetical questions, which often are questions about the other lawyer or something that's already occurred. And I can't advise regarding judicial canons. If you have a question about judicial canons, judicial conduct, you can contact the Judicial Inquiry Commission. Since if you're not a judge asking about yourself, they're probably not going to give you the answer. The same way I won't give you an answer about someone else too. However, they have just improved their database, where they have a better searchable database of their opinions And they are helpful, and they might be able to direct you to a canon that you might want to look at, or put you in the direction of an opinion on point. I'm also not able to give you an opinion on issues that are properly before court. For example, a motion is qualified. I'll be glad to provide some guidance along the way that we would look at those issues. But if it's a question, it's a court question, then we're going to be very deferential to the court to solve, to answer those questions, which often deal with a dispute of facts. So there are certain things that would it be malpractice? Is it okay that I already did this? Does someone else have a conflict? What about the judge? Is something privileged? Privileged if incompetent can be forced to disclose something. That's a legal question. What am I permitted to disclose outside of proceeding confidentiality? That's a professional responsibility question. Or did you tell her she could do that, right? It's a confidential service. If you go mention to another lawyer that you saw an opinion and the other lawyer calls me, I'm going to tell them, well, I can't confirm whether somebody called me, much less tell them what I said or what we discussed. It's a confidential service. So if you're going to go tell someone you got an opinion, you should be prepared to authorize the disclosure of what we talked about to that person. And if the lawyer isn't, conversely, if the lawyer says, well, the bar told me I could, and they're not authorizing the disclosure of the opinion, then you might as well go ahead and proceed if if you don't believe that's an accurate assessment, or it's maybe something often it's a question before. Big picture, we have to be deferential. We defer to the trial court concerning disputes of fact and questions of law. If it's already happened, it's a matter where deference to disciplinary commission, disciplinary board, it's something that's already done. It's within their purview. And the Rule 18 of the Alabama Rules of Disciplinary Procedure, which authorizes the provision of these sorts of opinions, only contemplates opinions to a lawyer about his or her own perspective. When we think of these two different divisions, what they do, we do different things. I don't forward complaints. If someone calls me with a complaint, and I'll be glad about another lawyer, I don't forward that information. I can't take reports and send it to them. I don't have access to their disciplinary file, anything that's going on. I can have the information that I can access about a pending disciplinary matter which hasn't been resolved is the exact same that any member of the public can. I just don't have access to those databases, and I'm glad I don't have any interest in participating in that side of the house, frankly. But I don't have this information, and it's not reported. Conversely, they don't have access to my database. They don't have access to my information, and we have physical electronic controls, screening policy procedures, separate divisions. We're on a different floor, and so there is that division between the two offices. Like Ramon mentioned, some other member services and some news from the bar. The departments, we do have a volunteer lawyers program. Linda Lund is retiring, and Hillary Armstrong, who's currently the pro bono committee coordinator, is taking her place. It's wonderful. Hillary does a great job. Linda does a wonderful job. They coordinate a lot of opportunities to do pro bono work, which is something that we should all try to do as much as we can, provide benefit to the public. We also have some news for the law practice management program. Chris Coley is the law practice management advisor. However, he is moving on and taking advantage of another opportunity. As of January 1st, I believe the law practice management program advisor position is currently open. It provides a very important service to bar members, and whereas the ethics division provides guidance on the rules of professional conduct, the law practice management program provides practical advice on issues from the start of a law firm to opening your firm to closing your program and everything in between, including direction about resources can help you, technology that's available. There are a number of forms and guides, including ones that are online under the law practice management page, which you can access that'll help you in your legal practice. We also have a lawyer referral service, which you can sign up for and get connected to potential paying clients. Whereby having proven malpractice and completing the information, paying a very small fee to be a part of the referral service. There's a callers with needs in a particular area are rotated through lawyers who are participating in the service, and some lawyers have had some very successful cases that have come out of this service. For a moment, there are a lot of scams targeting Alabama lawyers. I think I probably get 4 or 5 emails a week, which I don't respond to, but I think they are part of scams targeting Alabama lawyers that often start with emails, but can also start with other social media, other contacts. They follow some common patterns. There's a settlement collection fraud is a popular type of scam pattern where it's the initial email says, "Hey, I need help collecting past due spousal support. I have a settlement that I've agreed, so they haven't paid my settlement. There's a wrongful termination. Typically, it's, hey, there's been a settlement and they owe me money." The pattern that's followed, it often comes from someone located in another country, but not necessarily. You respond to the email, they provide documents, sign the contingent, sign your fee agreement, they agree to pay your fees. You look it up. They use names and details from real companies, using real employees, and sometimes connect mailing addresses. However, often there are different phone numbers and email addresses that they use to correspond with you. The major part of this pattern is the check arrives very promptly, right after you agreed to representation, and sometimes before you formally agreed to undertake representation. The scammer says deposited, keep your fee, send me my chunk, and thanks for all your help. The check is often sufficiently sophisticated to appear to be legitimate, but by the time that you deposit the money, and if you wire it back out or you send them their check, it can be discovered that it's a forged check, and then you're the one on the hook. Almost every email that you get involving a dredger is probably, or some sort of offshore equipment, when you are a lawyer at a small firm in Central Alabama, is going to be part of a attempted scam. Business loans, equipment, often have equipment purchases, same pattern as the settlements. There also is the real estate fraud, where sometimes there might be a deposit of payment to you made it's purportedly used to pay for the property, but then a request for a refund minus your fees, and same pattern that results in the money. It's a fake, and ultimately the lawyer's on the hook. They often start with an inquiry. It's a cold call, a cold email, a cold contact via email, through your website, through social media, sometimes with fake documents and checks. And I do have the documents from one particular settlement collection case. And this is somewhat dated. It's a 2019 that follows this pattern. In this case, it started with an email from Takahiko Takahashi, president, representative director of TDS company, who needed help collecting his $700,000 settlement agreement he agreed to the hospital for a broken leg and brain damage. The email contained links to his company's website. He's the president. Well, it turns out maybe you don't, maybe you only know English, but there was an English version in this case. And if you look on the English version of the website, you can find Takahiko Takahashi is the president of this company. So maybe you think, hey, it can't hurt to ask for more information. Let's respond. We don't want to miss an opportunity. So the lawyer sends an email back, says, okay, well, yeah, let's get on the phone. We can talk about it. I got your email. Not expecting much. It turns out, Takahiko Takahashi, President Takahashi, very quickly responds. He's not going to be able to engage the telephone call, but he does send the information to do your conflict check for this case. He has a broken leg and severe brain injuries, and unfortunately, using the phones can be dangerous due to the radiation, but he is very seriously injured, and he's going to send you a copy of the settlement agreement for you to take a look at very quickly. Well, you see that when you look it up. Well, I guess this hospital is a real hospital. I looked up on the website, I checked on it. Yes, it exists. And I sure would like a boat. That money would be useful right now. Doesn't seem like a real complicated matter. Wouldn't it be great if this was real? I suppose I went myself to find out if this is legitimate. Okay, well, here's our contingency agreement. We're going to need to evaluate the case, and I'll send you our employment contracts and your documents. We're all doing this on October 19th, same day. Very quickly, President Takahashi sends an email back and says, oh, well, great. I've got the release and settlement agreement. And so you do your conflict check. Please let me know. I'll be glad to sign your contract. Thanks for your help. So we look at it real quickly. Who are the parties? Got to do the conflict check. All right, we have a signed settlement agreement. I guess so. Mountain View Hospital, $700,000. That's great. Who signed it? Looks like it's signed by the CEO, chairman of the board, medical director for the hospital. This is silly. This is too good to be true. Let's look it up. Well, yes, that is the name of the director of the hospital. We did get some medical records. That is Mountain View Hospital. Got the patient name. We'll take a look at that later. Well, almost immediately, a letter shows up. Or we get something in the mail. We don't really notice that it came from Canada, which would be odd for a Gadsden, Alabama hospital, but we get a letter with a check saying deposit. That is the amount, the portion of the settlement already due. Well, I got a check. I guess what do? I suppose I'm supposed to deposit my Ulta account. I stick it in my Ulta account. President Takahashi says, hey, you keep your 40%. Thanks. The bank teller says, well, the check looks fine. We can't see anything immediately wrong with it. You deposit the check and the Ulta balance shows that the funds are immediately available. Huh. Well, this is, I might be a little bit skeptical. This seems too good to be true. Good stuff never happens to me, but you know what? It's my turn. It's my turn to be lucky. Got to do some math. Okay, 40% like that. That doesn't sound too bad. I'm gonna have to come up with a name for my new boat. But let's not get going too fast. Let's wait. What am I supposed to wait a week? I'll wait a week just to be sure. President Takahashi also is saying, hey, I would like you to borrow my settlement funds, and you're waiting. And well, surely if there's a problem with a check, I'd know about now. I've already settled it on fee simple. That's what I'm going to name the boat. I'm looking. So it's been a week. The money's still there, and President Takahashi's getting impatient. He says, maybe I shouldn't get the fee because it didn't really do that much. It's already been a week. The bank hadn't said anything. The funds look like they're available. I'm going to go ahead and wire the client, President Takahashi, his portion, and I'll move my portion to the operating account, and then we'll take the day off for some boat shopping. Well, that's not going to work out well for you. Bank lets you the check was forged. 10 days later, it says, oh, it's forged. We're going to take that money right back out of your Alta account. Now you have other clients' money missing from your Alta account. If there was a negative balance, the bar got noticed, and I've got a letter coming from the bar. I know that I have a duty to promptly deliver clients their funds under Rule 1.15b. Of course, that's after they're collected. I can disperse them before collection at my own risk. And availability does not mean they have been collected, but if collection doesn't occur, then I have 5 days to fix it. I have to replace the funds in the account. Were there some red flags? Could this have been avoided? Commonly, if you look at these documents, there would be the timeline. Wow, this is really fast. Lots of typos and the use of webmail accounts. Maybe an odd choice of bank, like a Gadsden company using a Canadian bank, or a check issued to you before you even agree to represent the party. Maybe if you go back and look at the documents, sometimes there are obvious errors in the documents, like who's Yoshihiro Suzuki? I thought I was dealing with Mr. Takahashi. That doesn't seem right. I didn't notice that at first. Or we got some medical records where I thought it was Mr. Takahashi, but the records are for a female with an umbilical cord prolapse who was there to get a flu vaccine, a pneumonia vaccine. Dr. Carl Savum, that name's kind of on the nose. He went back to the site of his slip and fall for treatment of brain damage and a broken leg, but he's going to set up his annual exam for neuropathy and check his insulin. This all doesn't add up. It's a hodgepodge of records. I know we're worried about him working on his diet and his insulin and coming back to check his feet, but that's really not These records don't match. Now, they're not always this obvious. They're, of course, getting more sophisticated, but they're often a lot of red flags on the documents themselves. Like, for example, a psychiatric hospital providing all these services for severe brain damage. Often, in this particular example, there was multiple websites listed, and if you go back and look at with the other website listed on one of his emails, you find it's a different company, and that's where President Suzuki is. It's actually the same scammer who sometimes uses President Suzuki, sometimes uses President Takahashi. And we have an example, at least initially, one of the examples of this came in differently around the same time period to another lawyer through AVO when it came with a slightly different name when it came to the lawyer providing the documents, who did not disperse the funds. They did not make this mistake, but he was nice enough to send them to me to use the presentation. So when you're a victim of scam, do I have a duty of confidentiality to people who are attempting to scam me? No. You may notify law enforcement that there's been an attempted scam. There's not a lawyer-client relationship. If it's clearly fraudulent, you can, you're the victim here. There is no duty of confidentiality. Now, unfortunately, the scammers are getting better. There are fewer obvious errors. I mean, they're using AI. One thing that I've seen, often they're using local companies, and they appear, if I'm in Wetumpka, Alabama, and I'm contacted by a president of a foreign company, I have some red flags. You're probably wondering why they contacted me, but it doesn't probably that often, or probably more often, they're going to use local company names. I think they go find companies that don't have a website, and sometimes they are setting up websites for companies that exist, but they are actually setting up dummy websites with it's going to have information to assist them in this fraud. One thing you can do, and often when people have called me and trying to ask me for help for more sophisticated versions of scams, like, okay, well, what's this website? Let's go look up the website. And we find out the website was the domain name is registered in the last 6 months, right? So checking who is a good way to go. Look up and see, check on legitimacy of some of these claims. There's also a website that has a number of warnings on it. It's avoidaclaim.com. A number of our bar association has issued any guidance very recently on scams, but if you look up scams, there's a lot of services that kind of can get you the direction of looking up fishy sounding phone calls and to see, hey, is this a potential issue here? Now, this is the other thing. The other thing you certainly need to be aware of in your law firm is a different sort of phishing schemes, which use links that send you that are intended to then take personal information, or make sure you have appropriate virus protection. Train your employees on avoiding clicking on links and downloading information from cold calls or cold emails. I'm not an expert on these areas, but find somebody that can do regular training for the members of your law firm. All right, at this point, I don't know how to, I see we have a raised hand, but I'm not really sure how that. Okay, let's see if I can. David, there's some questions. I see some raised hand and some questions. Are you able to help me? I'm not really sure where I can find those questions on my end.
Let's see if we can pull those up. A moment here. Not seeing anything in our chat section.
Okay, I see raised hands, and I'm just not sure what to do with that. So I'll just proceed, and we'll wait
No,
if there's something in the chat. Okay.
No, proceed on. Thank you.
For not being these, not knowing how to answer those. But those are scams targeting Alabama attorneys. I thought, since we have some more time, we can go over some rules of professional conduct in my presentations, which works a little bit differently when we are in person It's often an interactive question and answer section on the rules of professional conduct, where I quiz members of the audience with some questions about the Alabama rules of professional conduct. One of them being true or false. The ABA rules of professional conduct, which are tested on the multi-state professional responsibility exam, govern the professional conduct of Alabama lawyers. Well, that's false. Alabama lawyers are subject to the Alabama rules of professional conduct. The ABA's model rules are the ones tested on MPRE. They are similar but not identical to the Alabama rules of professional conduct. They could be a useful source of information on areas where we don't, where Alabama doesn't have formal opinions. But if the rule differs, you have to be careful, because if our rule differs slightly, that can have meaningful consequences for the rule and its interpretation in our jurisdiction. So you have to be mindful of whether or not the rules are the same or they are slightly different. But it is a useful resource. So if you ever have any questions, call me and we can go look into it. And often, if there is not a very clear answer, good opinion on point, we will go to I will take you to the ABA model rule and their commentary, their annotations, and we can go back. I get a lot of questions about Rule 4.2, communication with persons represented by counsel. That's Rule 4.2. True or false? Consent from corporate counsel is required to speak with a current manager for the represented company. True or false? I need consent from company's attorney to talk to a current manager for the company about the subject matter of the representation. That's true. That's our non-contact rule. There are several categories of current employees we can't talk to. Current managers, persons whose act or omissions give rise to liability for the company in the case, or persons who have the ability to bind the company in litigation. Typically, those are the corporate employees who are communicating, counseling, and actually directing litigation. Often, they're going to be in the managerial category or some sort of officer with off limits for the company. True or false? Consent from corporate counsel is required to speak with a former employee who was a manager about the subject matter with the representation. True or false? I need consent from company counsel to talk to their former managers, because they were managers when they were at the company, about the subject matter representation. That's false. If it's a employee who is a current manager, off limits. A former manager, you can speak to them. A person whose act or omission gave rise liability to the company in the matter, who's a currently employed, off limits. Previously employed, Rule 4.2 does not apply if they are not separately represented. Now, it's possible they could be actually represented by an attorney, or including the attorney for the company. But that's the first question asked. If they're not actually represented, they are not off limits merely because the company is represented in their employees. But that doesn't mean you can do whatever you like, and you can speak about whatever you like with them. Other rules do apply. For example, Rule 4.3, the rule that addresses dealing with an unrepresented person. You can't state or imply you're disinterested when you deal with an unrepresented person. And you need to go let them know why you're contacting them who you represent. And Rule 4.4 it's the rule relating to respecting the rights of third persons. Is the rule that says that you can't invade the privilege, right? You can't use means of acquiring evidence that violate a legal right of the other. You can't seek or allow the disclosure of privileged communication by the former employee. So when you talk to the former employee, you start with, are you actually representing it? No. Tell them who you are, tell them why you're contacting them, tell them that you don't want to know any information that they discussed with counsel from the company before you proceed. There's an ABA opinion, the ABA opinion 1991-359, which is an example of an opinion cited by and adopted by our opinions, which is used to deal with this topic in depth. Rule 1.1 is our confidence rule. It requires competent representation to apply. True or false? A lawyer's duty of competence prohibits her from undertaking a legal matter in an area in which she does not have special training or prior expertise. That's false. Everybody has to start somewhere, but you need to make sure that you do whatever's necessary to make yourself competent for the purpose of the matter they'll bite off it, and you can get assistance from other lawyers who have experience in that area if need be. And also remember, when you are taking on these matters, that you can't charge a clearly excessive fee, so sometimes you're not going to be able to charge for, if you charge on an hourly basis, you might not be able to charge for all the time you spent because it took you longer than you should have. All right. Question 5, true or false? Lawyers are disciplined for violating the competence rule more than any other. That's false. Lawyers aren't disciplined for this violation very often, even though it's a common element. But there's a rule to reminder that you need to make sure that you do provide competent representation. Malpractice is often referred to for incompetent representation. And from the bar perspective, often the Beasley 1.1 issues tie into other things like issues of diligence and communication. True or false? The most frequently violated rules of professional conduct, as judged by the results of disciplinary proceedings, are rules 1.3, the diligence rule, 1.4, the communication rule, 1.15, the safety and property rule, and 8.4, the misconduct rule. That's true. Okay, the most time, the diligence, communication, or common violations. When we talk about serious violations, the rule 1.15, the safety and property, you mess up your relative account. You fail to fulfill those obligations, it's typically a serious issue. It comes with serious consequences, and it's often the easiest to prove because money is either in the account when it should be or not. It has been deposited directly in the account. When we think about those common reasons people file bar complaints in the first place, it's often dissatisfaction with the pace of the representation and dissatisfaction with the amount of communication. Oftentimes, the pace of the representation is outside of the lawyer's control. The amount of communication sometimes is perfectly fine, but the client's expectations are not reasonable. So it's important to educate your clients at the outset about the reality of the pace of the matter and how long things are going to take, and also manage their expectations about what communication they're going to get from you. Set reasonable, identify a reasonable amount of communication, and then comply with what you told them. It is not necessary to talk to a client every day in most matters. It's typically not necessary for you to give the client your personal cell phone number, and don't get yourself in a situation where you communicate far greater than as is necessary at certain points, create a unreasonable expectation for your responsiveness, fail to establish the appropriate the amount of communication or reasonable limitations. And if you have an unsophisticated consumer of legal services, you might end up with a dissatisfied person you're providing wonderful representation to, sufficient communication, who is dissatisfied because their expectations aren't met. And so I try to manage those expectations with client education at the outset. True or false? All fee agreements between a lawyer and client must be in writing and signed by the client. Well, that's false. Certain agreements, a contingent fee agreement has to be in writing. Certainly it is preferably in writing. It's included in the rule 1.5b. There could be certain sorts of representations which not without covered by our rules, where the nature of those particular matters includes a written or signed requirement, but it's not in our rules. But true or false, all fee agreements between the lawyer and client should be in writing and signed by the client. Yes, definitely. Often do this for yourself as much as anything else. The lawyers chased out of fees very often when they call me, and they don't have proper documentation at the outset. And the client remembers things incorrectly in a way more favorable to the client when it comes time to pay the bills. So make sure that you have your written agreements correctly signed by the client to protect yourself with everything. True or false? You may not enter a sexual relationship with an existing client or accept sexual favors as compensation for services unless the client makes the first move. Great. Some lawyers in Alabama have gotten this answer correct, but the answer is incorrect, but the answer is false. Right? Sexual relationships with clients are presumed to be exploitative. So it also, remember when we talk about these relationships that it can also be a relationship with a representative or agent for the client. So if you are a relationship with a parent of a child, a client of a child, or someone else associated with the client can also follow this rule. So true or false, it's sometimes okay to have a sexual relationship with a client. All right, that's false. You could have a spousal relationship. Maybe you have a relationship that exists prior to the representation starting, but remember, even if it started before the representation, you have an ongoing duty to make sure that the personal relationship does not affect the representation and withdrawal if it does. Question 11, true or false, lawyer may represent a client against a former client in an unrelated matter, provided the lawyer did not obtain the confidential information during the representation of the former client with risk disclosure, or could in any way be used to disadvantage the former client in the matter. True. This is the most common question or sort of questions I get relate to former clients or consulting prospective clients and conflicts of interest. And that prior statement is the succinctly not the best, but a statement of how that rule works. Are you barred from being adverse to a former client forever? No. You're barred from representing a new client in the same or substantially related matter that which you represent. And that's an ongoing loyalty obligation that's matter specific. But you don't generally have a duty to never be adverse to a former client. But you also have a duty not to use a former client's information against them. You have an ongoing rule 1.62 of confidentiality says I can't disclose information related to representation under consent. So you could run into a situation where if information that you have gained in the prior representation of the client could be used against them in the new matter, well, you're going to have a conflict in the new matter because you're stuck between a duty to not use the former client's information against them and a duty to zealously advocate for the new client. So if you're stuck in that position, you have a conflict, and that can even be the case when the former client isn't a party to the new matter. If you have a former client who shows up as an adverse witness, you could have a conflict representing the new client if you have information from the representing client that's been used against them. For example, attack the credibility and keeps their testimony. You could have a conflict based on under Rule 1.9b. I think we're just about out of time. True or false, all retainers must be deposited in the attorney's trust account because they are not earned at the time of receipt. It's true-ish, technically false. We talk about retainers, we're talking about unearned fees, something paid in advance. If it's paid in advance, it's not your money at the time of receipt. It goes to the alt account with a very limited exception. What is that exception? What type of retainers earn time receipts and should not be deposited into the alt account? That's a true availability only retainer. That's the payment to you to be available to the client, to represent them in the future, to not undertake representations which might conflict, to not not fill your advance card so that you cannot provide the services to them when they need it. Those payments, those are earned when you get them. Those go in your pocket. But in those circumstances, a true availability retainer means they're going to pay you the actual money to do it later. So that's the thing. True or false, unlike retainers, flat fees paid when lawyers hired or earned the time of receipt and don't go in the alt account. Well, that's false. If it's paid at the time you're hired, it's going to go in your alt account. It's an advance payment. If a portion is for something you haven't done, it starts the alt. Or if you get a flat fee, does that mean that you have to hold the whole amount until the conclusion of representation? Well, that's not correct, right? You withdraw it over the course of time. All right, so how do you know when and how much you can withdraw? Well, one, let's put in that contract, but ordinarily in the default would be at an hourly rate with a stated rate over time. Now I'm doing that, I need to let the client know that I have deemed certain amounts earned as I withdraw amount. So they can't provide information, so if they have a problem, they can let you know on time when at the time you have that issue. Now, you think about flat fees, one of the benefits of flat fees, I guess there's cost certainty. But if you have to record your time and send these invoices to the client, what's the benefit of having a flat fee agreement? Well, you're still going to have that administrative burden if it's on an hourly basis. So a better way might be to set milestones in the representation where we can conclusively deem these portions earned. So if you have reasonable milestones in a representation, it can be something where that you can deem it as earned. You can pay yourself, and the client is not going to be able to argue with you about you spent too much time doing this or that. If you have reasonable milestones, when you get those milestones, they can stop the arguing. It keeps you getting chased out of fees that you've earned, and you don't want to do that out of fear of the bar discrimination process. So, of course, you can't use some sort of subterfuge. You can't characterize a flat fee. You can't say, well, look, the fee is $5,000 and I'm going to earn $4,900 at our initial meeting, and I will represent you for the rest of the divorce for $100. Well, that's not. That's circumventing the rule. That's not permissible. True or false? A lawyer's conflicts with the other members of her firm pursuant to Rule 1.10 can't be avoided by screening. That's true. Imputed conflict rule means conflicts are imputed between law firm. When you're talking about private firms, you can't use screening mechanisms to shield members of law firm when you're talking about default like conflicts under 1.7, 1.8C, 1.9, and 2.2. When you leave the firm, however, those conflicts go with you. So you're only, if the lawyer leaves the firm, a conflict imputed to the lawyer while at the firm stays at the firm as long as that lawyer themselves represent the client or acquire information which is problematic. So an imputed conflict, which is solely a conflict-based firm imputation, does not leave with the lawyer. True or false? Hiring a non-lawyer employee with confidential information about a matter acquired to form the firm can result in a conflict disqualifying the firm from continued representation along that firm. True or false? If I hire the paralegal for opposing counsel who's worked on a matter, I'm out, even though it's not a lawyer. That's true, right? That doesn't mean you can't hire these non-lawyer employees, but hiring them could come to the consequence of disqualification from your case. Keep that in mind. I know that's not all jurisdictions have this rule. I know it's something that our general counsel is considering revisiting, but for right now, you can't use screen off conflicts from non-lawyers changing firms in the same way you can't use screening to solve it when a lawyer changes. True or false, the client is entitled to a full copy of the file or the original file at the end of the representation, but if you've given them that, you can charge them for the second copy. That's true. The file is theirs. They're entitled to the original file or a copy in the representation. It might be a good idea if it works for your practice to, at the end of the representation as a policy, provide it and save your copy of the file electronically, require them to take away the original file, sign that they've received it, that they understand that there's a cost for additional another copy, and that it's going to be destroyed in 6 years or whatever the retention period for those documents, and you're not going to keep it. True or false? You can require a client to delegate settlement authority in your contract, and refusal to accept a good settlement offer is good cause for withdrawal. That's false, right? But you can't have the client delegate settlement authority. Like if you have a settlement offer, you have to run it by the client. The client has to agree. They can't give pre-authorization, and it's a pretty, like, you can withdraw if the continued representation of a client would create an unreasonable financial burden for the client, for the lawyer. However, that doesn't mean that the client will take a good one and wants to go to trial. Right? That's a high threshold. You know, we talk about a lot of these plaintiffs cases. You get a premium on your fees sometimes, so that's part of the deal. Sometimes they want to proceed and they want to do what you don't think is a wise thing, but that doesn't necessarily mean you have good cause for fraud. True or false? You can pay your own personal expenses out of your LLC account, for example, your license fee, as long as you've earned those fees that are sitting in your trust account. That's false, right? You have to move them out of your trust account to, once they're earned, you can't use your trust account as your personal account for which you pay your expenses, your personal expenses. You can pay a client expense. I can pay the filing fee from my trust account, but I can't pay my own personal expenses just because, well, I've already earned that portion. You have to pull it out. that is a shockingly large number of flies to go through in a short period of time. I think I'm done.
So Tripp, sorry to interrupt. I think we've reached the noon hour, and sorry to cut the question short, but we do have two questions I would love to pitch to you. And on behalf of all our viewers, I want to thank you for a fantastic presentation. We do have a question from Cheryl. She asks if you can confirm that if we ask a prospective ethics question of the bar, it is fully confidential. And she is currently located in Florida.
Yeah, they're confidential. They are not disclosed to disciplinary division. There is, that's the only way they get disclosed to the other side of the wall, like to the other side, is if you use it as you respond in a bar, you say, hey, disclose it, or you respond to bar complaints that I got an opinion which said whatever. You don't have to, you don't have to follow any advice I give, and it is not something that somebody else calls and wants it. So I'm not going to confirm that they even ask the question. That's what we talked about, unless you tell me if I can share it. It is a particularly confidential service. I think your team acknowledges the confidentiality of the procedure, acknowledges the confidentiality of these requests. No one's ever tried to force to compel disclosure, but if there was anything outside, we would make the argument you can't make it disclosure. I think it's just
Okay. Two other questions. The first one is from William. William asks, in Alabama, does a plaintiff's lawyer have the responsibility to protect an ambulance bill where there is no letter of protection and no judgment?
Okay. Our answer, we stop at part of that's a legal question, right? Well, I mentioned I can't answer your question, but we'll talk about a plaintiff's attorney in Alabama. You have a duty to, if you have a legal duty to protect it, then you can refuse to disperse your client and you have a legal obligation to someone. We don't catalog all the different circumstances where a lawyer might have a legal duty to protect the interest of a third party. If you absent the legal duty, which is the one I can't do, there's some obligations, there's some statutes where you do have an obligation, and if you do have that legal obligation, then yes, you have a duty to protect it. Then you'd want to protect it because ultimately, in those circumstances, you are liable for failure to protect it anyway. But you're not going to get in trouble for not dispersing your client when you have a legal obligation to protect. Separately, if you do agree to protect the third parties in the absence of a legal obligation, so then you have an obligation because you promised to protect them. Right? When I'm going to promise to protect a third party, my client's consent, I'll set up when I'm going to issue that letter of protection. But there are circumstances where you do have a duty to protect. Oftentimes, if you fail to protect it in that circumstance, though, it's much of an issue you're going to have because you're on the hook for the third party. And that's your biggest problem is the collect responsibility and protection. Because then you are making that be very fun.
Well, I think that's all that we have time for today. We did have one CLE credit question, but I think that's something that they can probably suss out by going to the Alabama State Bar website or reaching out to the CLE office there at the bar. For those of you who may have missed our earlier announcements, by the end of this week, you'll receive an email with an evaluation form, an updated presentation, and our video link. You can email your completed evaluation form to webinars@beasleyallen.com. Again, for those of you who are participating by phone, it's very important that you email us your name, your phone number, and state bar ID number. Send that to webinars@beasleyallen.com. That will help us ensure you receive full CLE credit for today's program. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be hosting a wide variety of new programs and other special events throughout the coming year. Thank you all for joining us today, and happy holidays to each and every one of you and your families. Thanks so much.